Good morning, colleagues. I am testing the sound. Can you hear my voice? Can I see your thumbs up? I will start in 1 minute. Ofenze, I see your hand. Please come through before we start.
Sorry, lady. I was trying to do a thumbs up. Sorry, there was a mistake.
Oh, okay. But you can hear my voice. I can also hear yours. I think let's start. It's 10 o'clock. Good morning, stakeholders. Welcome to today's webinar hosted by the PPRA in collaboration with Free State Rental Housing Tribunal. We are very pleased to have both consumers, attorneys, and property practitioners and other stakeholders joining us this morning. Today's theme is understanding the PPRA Code of Conduct. And I'm sure for some property practitioners, you've received a complaint against your firm, against yourself at some point, and maybe you were not sure how to navigate that. And just to understand the do's and don'ts, in respect to the code of conduct on how to protect yourself, in your professional. And also we're going to look at rental tribunal dispute resolution today. We have a guest speaker from rental tribunal. So today's conversation is very important for both tenants and landlords and practitioners, as it aims to unpack the legal and ethical expectations set out by the PPRA. And we also want to provide clarity on processes involved when disputes arises in the rental space. As we know, some practitioners, they operate in rental, some in selling, some in both. We are honored to be joined by our two speakers today. Mr. Clarence Caton, I'm sure some of you know him by now. He has done several of our webinars since we started the webinar journey in 2024. He is the Executive Manager for Investigations and Enforcement here at the PPRA. He has an LLB and MBA. He's an admitted advocate of the High Court of South Africa, and he comes with 15 years experience. So I think it was important to mention that because of, the information he will be handing out today, and he's worked in enforcement. He's occupied, different positions within the regulatory bodies around before PPRA. He's been working with other regulatory entities in South Africa. And we also have our second speaker, Ms. Ofenze Seate, from Deputy Director, Rental Housing Regulation from the Free State Department of Human Settlements. Ofenze, she is the manager there at the Rental Tribunal in the Free State, and she's going to take us through dispute resolution. And this collabo, colleagues, and maybe let me mention this, that the reason why we felt it was fitting for Rental Tribunal to come and explain their processes is because some consumers, they would be sending complaints within our adjudications department, and you find that the PPRA, they don't have jurisdictions maybe on issues of tenants, and we would refer them to rental tribunal, hence the collaboration, but it will be clearer as they present and speak and answer the questions. Let's quickly go through the housekeeping rules for today. You will be muted throughout the session until the presenters are done with the presentations so that we avoid background noise. We encourage engagement. All the questions, please put them on the Q&A space, also put them on the chat. I will be monitoring the questions as and when, but we're going to address all the hands, all the chat in the Q&A segment after the presentations from both our speakers. The session is being recorded, colleagues, for educational and references purposes, and we're also going to put this recorder on our PPRA TV. You will find it there for those who couldn't even attend or you want to listen again on that. The slides, yes, we're going to share with you. We have your email addresses. We're going to share all the slides after the webinar. Should you experience any technical issues, can I ask that you log out and you log in again? Just refresh your system and check that all the volume settings on your side, they are on 100%. I am not going to waste any time. Let me allow Mr. Caton to come through with his presentation. Can you please unmute yourself, sir, and take us through the code of conduct? Thank you.
Good morning, Naledi. Thank you very much for the introduction. And good morning to all those present. First of all, Naledi, just confirm, am I coming through clearly? You can hear me?
Yes. Yes,
right.
Can we put it on slide mode?
I'll put it on slide mode. So my presentation is clearly visible to everyone. And Naledi, can you just confirm it's on the screen?
Yes, they're even giving us the thumbs up. They can see it.
Perfect, thank you very much. So Naledi has already given an introduction. So maybe just to add to that, and I think she did mention it, the purpose of us embarking on this process to do webinars and other types of presentations is to get the word out there to property practitioners in particular, and also consumers who may be in attendance as well. We want to make property practitioners aware of what it is that they need to comply with, and this comes from if I maybe just give some background, the department that I head, we deal with consumer complaints, right? So in terms of the Act, a consumer may lodge a complaint against any property practitioner if the consumer alleges that there's misconduct on the part of that property practitioner. And we receive, on average, about 1,500 complaints per year, right? And we would like to start to see a reduction in the amount of complaints that we are receiving. And we believe that if property practitioners are aware of what it is that they need to comply with, then we should gradually start seeing that reduction. And that is the purpose of us embarking on this process, to make property practitioners aware of the code of conduct, because that is what you need to comply with. And if you comply with it, there should not be any complaints lodged against you in your practice. All right, so I understand that some of you may have already been present in this presentation. I ask that you just abide with us. I don't think it will hurt if you are attending for a second time. It's always good, maybe just to refresh your memory and your knowledge as we go through the presentation. All right. So I think let's just start. I like to start by just giving some context as to who the PPRA is, so that for those of you that do not know, PPRA be a public entity. We came into being on the 1st of February 2022. We took over from the Estate Agency Affairs Board, right? So all the functions that was previously performed by the Estate Agency Affairs Board is now being performed by the Property Practitioners Regulatory Authority. So we have various functions we've been established to achieve various objectives, and one of those objectives is to enforce the Act as well. And that objectives are set out in Section 6 of the Act, and it tells us that we must regulate the conduct of property practitioners in dealing with consumers. We must regulate the conduct of property practitioners insofar as their services are concerned, and we must regulate and ensure compliance with the provisions of the Act, and we must protect consumers from undesirable and sanctionable practices. And then we must regulate any other conduct which falls within the ambit of the Act. All right, so that is the mandate that is set out in Section 6 of the Act. That is the instructions that the legislator has given to the PPRA. That's the functions that we must perform, right? So just to give you, right, apologies, I'm just having problems moving my slides. Right, so I just want to also then just let you know what our legislative framework consists of, right? Remember I said that we have this mandate to that is set out in Section 6 of the Act, and the framework that gives us the powers to execute that mandate consists of these three pieces of legislation. So it's the Property Practitioners Act 22 of 2019. That is the act that established PPRA. That is the act that sets out our functions and gives us our powers. It's all contained in that act. And then we have the Property Practitioners Regulations, which was promulgated from the Act. There's a section in the Act that it empowers the minister to promulgate regulations, and that has been done. And those regulations are the Property Practitioners Regulations of 2022. And then we have the Code of Conduct. And the Code of Conduct is something that we will go through in a little bit of more detail during this presentation. But before we go through the Code of Conduct, I want to just highlight some important provisions of the Act that property practitioners must be aware of. Okay, so the Act contains, I think it's 77 sections. The Act is made up of 77 different sections, right? It's not possible for me to go through all of them. So I've identified the ones that I believe that are important for property practitioners out there to know. And it also is informed by the most common complaints that we deal with. And as I said, it's important that we inform property practitioners and create that awareness so that we will see that reduction in the number of complaints that we receive, right? So let's start with Section 4 of the Act. As I've said, there is an obligation on property practitioners to comply with our Act, with our regulations, and with our Code of Conduct, right? Now, Section 4 of the Act provides you with an opportunity to apply for an exemption, to apply to be exempted from certain provisions of the Act. If you, as a property practitioner, feel that there's certain provisions of the Act that you are unable to comply with, then you may apply for an exemption in terms of Section 4 of the Act. So please do take note of Section 4 of the Act. I take it that if you are a practicing property practitioner, you have a copy of the Property Practitioners Act available to you. that you have a copy of the code of conduct available to you. So please, these documents are working documents and documents that you must use on a regular basis. So take note of Section 4, of the contents of Section 4 and what it provides for. You may apply to be exempted from complying with specific provisions of the Act. Section 48, very, very important. It tells you that you may not act as a property practitioner unless you are issued with an FFC. And it also sets out if you employ any person as a property practitioner, that person must also be issued with a valid FFC. And it creates an offense for you to practice without a FFC. All right. Very, very important provision of the Act. Section 53 tells you or obligates you to display your FFC at your place of business. That section uses the wording prominently displayed. It says that your FFC must be prominently displayed at your place of business so that your clients can assure themselves that they are dealing with a registered property practitioner. And as you know, in order to become a registered property practitioner and be issued with a valid fertility fund certificates, there's various education and training requirements that you have to comply with. So displaying that certificate and making it available to your clients will give them that assurance that they're dealing with a professional person that is registered with a regulatory body. All right, so that must be displayed at your place of business. Section 54 deals with the keeping of trust accounts. If you are a business property practitioner and you're dealing with trust monies from clients, Section 54 tells you what your obligations are in terms of keeping trust accounts. It, amongst other things, speaks about the opening and keeping of trust accounts and retaining all trust monies deposited until lawfully entitled to it or lawfully instructed in writing to make payment therefrom to any person. So the money is kept in the trust account. Must remain in that trust account until you are lawfully entitled to it or lawfully instructed in writing to make payments from it. All right. Section 54 also sets out requirements for the winding up of trust accounts or other savings and interest-bearing accounts and the circumstances under which this must be done. It also provides for the appointing of an auditor and annually confirming or updating the details of your auditor. And then also there's a requirement that you need to submit your audit reports to us within a certain time frame which is specified in that section, right? Now, while I'm speaking about Section 54, although I didn't include it in the slide, I just want to also make you aware of Section 23 of the Act, which exempts you as a property practitioner if you have a turnover below 2.5 million from audit requirements, and provides that you may then have an independent review done by a registered accountant. All right, so if you have a turnover below 2.5 million, you may be exempted from appointing that auditor, and then you may then use the services of a registered accountant instead, and then send us that independent review that has been prepared by that registered accountant. And also, while we're on the subject of trust accounts, Regulation 2 of the regulations, also very important for you to be aware of. It provides for an exemptions from keeping trust accounts. There are certain circumstances which, if it applies to you, you will be exempted from keeping trust accounts. An example is where you have never received or you no longer receive trust monies. Then in terms of Regulation 2, you can apply to be exempted from the requirement to keep a trust account. All right. And then also Section 58 prohibits arrangements to use specific service providers or conveyances. So what we find in practice is that there tends to be standing agreements between property practitioners and conveyancers, in terms of which clients are either obliged or encouraged to use the services of that particular conveyancer, and the conveyancer in return for the work that is given to that conveyancer gives the property practitioner some form of reward, right? And Section 58 prohibits those types of arrangements. We've just recently released a communique jointly with the Legal Practice Council with regards to that practice. That's we've receiving increasing number of complaints about it. And so please, property practitioners, just be aware that you are not allowed to encourage a client or obligate a client or oblige a client to use a specific conveyancer, and then in return for doing that, receive some type of kickback from that conveyancer. So those types of arrangements are prohibited in terms of Section 58. Also, please be aware of Section 59. It creates a duty on you to notify us in the case of insolvency or liquidation, all right? And it also sets out certain requirements that you must comply with if you should become insolvent or your company or entity should be liquidated, all right? One of the requirements is that you must inform us in writing if this should happen, and then you must immediately cease to perform the functions of a property practitioner. But please do familiarize yourselves with Section 59 as well in the event that insolvency or liquidation may apply to you. Section 62, very, very important. It creates a duty on all property practitioners to comply with the Act and the Code of Conduct. And it specifically states that failure to comply will constitute sanctionable conduct. And sanctionable conduct will result in yourself being brought before an adjudicator who can either, if they find you guilty of that sanctionable conduct, impose a sanction as set out in terms of the Act. All right, so Section 62 specifies that failure to comply with the Act and the Code of Conduct will constitute sanctionable conduct. All right. Section 63 also very important. It prohibits undesirable business practices, and I'll explain later on during this presentation what is meant by undesirable business practices, and we will speak a little bit more about that later on in this presentation. Section 67 of the Act, very important. You may not accept a mandate unless the seller or lessor has provided you with a signed, fully completed and signed mandatory disclosure form. So no mandate without a fully completed and signed mandatory disclosure form. This contravention of this section is one of the common complaints that we receive. Consumers come to us, they purchase the property, they found defects in the property, and then they say, but there was no mandatory disclosure form when I signed this offer to purchase this property. And Section 67 specifically creates that obligation on you to ensure that the seller or the lessor provides you with that before you accept that mandate. And then that mandated disclosure form must be given to the prospective purchaser or lessee before they make an offer, not after they make the offer, before they make the offer, so that the offer is made. It's an informed offer based on informed information that is before them. They know if there's any defects to the property, which would be listed in that mandatory disclosure form. Right. So now we'll just take a little bit of a more detailed look at the code of conduct. So the code of conduct consists of two main headings, right? So the two main headings is the first heading is duties applicable to all property practitioners. The second heading is duties applicable to estate agents, right? And under duties applicable to estate agents, there's various subheadings. So that is the structure of the code of conduct. There's two main headings: duties applicable to all property practitioners, and then duties applicable specifically to estate agents. And then under that heading, various subheadings, it sets out duties in respect of mandates, duties to disclose information to your clients, duties to not make misrepresentations or false statements or use harmful marketing techniques, creates duties in respect of offers and contracts, duties relating to remuneration, and then it also specifies what is prohibited in terms of undesirable business practices, right? And as I said, when I spoke about the Act, as I said, the Act contains 77 sections. Similarly, with the Code of Conduct, there are various hundreds, well, over 100 provisions that make up the Code of Conduct. And it's not possible to go through all of them, right? So we've identified the ones that we believe are important for you to know, and the ones that come out in the complaints that we receive, right? The ones that are commonly contravened when consumers report complaints to us. All right. So let's start with the first heading, and this is the heading on duties applicable to all property practitioners. All right. So all property practitioners have a general duty to members of the public and other persons or bodies. And in terms of this general duty, they shall not, in or pursuant to the conduct of their business, do or omit to do any act which is or may be contrary to the integrity of property practitioners in general. All right. So your conduct must not be contrary to the integrity of property practitioners in general. This is a very, very broad provision. All right. So it creates an obligation on you to always take note of your conduct and ensure that it's in line with what one can regard as complying with integrity, that it doesn't it's not contrary to what one would regard as conduct of integrity. All right, very broad, but please keep that in mind. All right. Also, property practitioners shall protect the interest of the clients at all times and to the best of their ability, with due regard to the interest of all other parties concerned. I think this is straightforward, self-explanatory. Your client's interest is should be at the top of your list when it comes to what is important to you, and you must act in their best interest at all times, right, with due regard to the interest of all other parties concerned. Property practitioners must not accept a mandate if the performance of the mandate requires specialized skill or knowledge falling outside their field of competence, unless they will, in the performance of the mandate, be assisted by a person who has the required skill or knowledge. And this fact is disclosed in writing to the client, right? An example I can use there is offers to purchase normally contains a lot of legalese. If you're not able to explain those clauses in that offer to purchase to the client, please refer them to a conveyancer that is more skilled in and has the required knowledge with regards to the interpretation of that offer to purchase. Right. Also, a property practitioner shall not, in his capacity as a property practitioner, willfully or negligently fail to perform any work or duties with such degree of skill, of care and skill as might reasonably be expected of a property practitioner. So you have a duty to perform your functions with a degree of care and skill as might reasonably be expected of you as a property practitioner, all right? And then it also, this provision also creates an obligation on you to comply with both the Act, these regulations, and all applicable bylaws. Right, so the next heading, and this heading is under duties applicable to estate agents, right? So now, the provisions that I dealt with in the previous slide was provisions that apply to property practitioners in general. And the provisions that I will deal now with in the slides going forward are duties applicable to estate agents in particular, right? So the first duty is duties in respect of mandates. So property practitioners must have a mandate from the seller or leasehold before proceeding to market a property, right? The same applies where the client is the purchaser or lessee. I think that's self-explanatory. You can't start marketing the property without a mandate. The mandate comes first, right? Sole mandates or the extension of an existing sole mandate must be in writing and be signed by the client, and the expiry date of the mandate must be recorded in the contract. Please take note of that requirements when it comes to sole mandates. It must be in writing. If there's an extension of it, that must also be in writing and must be signed by the client, and it must specify the expiry date. It must be contained in that contract, right? Then you may not accept any mandate or instructions for work in respect of immovable property if you have an interest therein that would compete with your obligations towards an existing client in respect of the same immovable property without first disclosing such interest in writing to the client. All right. So take note of that. It does not say that you can't accept a mandate in respect of immovable property in which you have an interest. It says that you must disclose such interest in writing to the client if your interest would create a conflict of interest and compete with your obligations toward that client. Please then disclose that interest in writing to the client. And then you may not knowingly or negligently make a material misrepresentation about the market value or rental income of the property in order to obtain a mandate in respect of such property. I think that is also self-explanatory. Don't tell the client that the property is worth 10 million, if it's not, just to try and persuade that client to give you the mandate. That is prohibited in terms of this particular provision. Right. Okay, so the next heading is your duty to disclose. All right. So property practitioners must convey to a purchaser or leasee or a prospective purchaser or leasee of immovable property in respect of which a mandate has been given to him to sell, let, buy, or hire, all facts concerning such property as are or should reasonably, in the circumstances, be within his personal knowledge and which are or could be material to a prospective purchaser or leasee thereof. Also, this is also a common contravention that comes through in the complaints that we receive. Many consumers allege that the property practitioner did not um, disclose all the facts, and they found out later certain facts relating to the property which were material to them. All right. So you have a duty um, if that if it's a fact that is within your personal knowledge or should reasonably in the circumstances be within your personal knowledge and which are or could be material to that prospective purchaser or leasing, you have that obligation to disclose that facts to that purchaser or leasing. All right. Then no estate agent shall purchase directly or indirectly for himself or acquire any interest in or conclude a lease in respect of any immovable property in respect of which he has a mandate without the full knowledge and consent of the person who conferred the mandate, or sell or let his own immovable property or any immovable property in which he has any direct or indirect interest to any prospective purchaser or leasee who has retained the services without that purchaser or leasee having full knowledge of ownership of or interest in such immovable property. All right. So if you go into purchase directly for yourself, property in terms of which you have a mandate, please, you must notify or disclose that to your client, and you must obtain that person's consent. All right, the person who gave you the mandate, you must obtain that person's consent to do so. The same applies if you sell your own immovable property or property in which you have a direct or indirect interest. You need to disclose that to the prospective purchaser or leasee before you do so. All right. So please take note of that provision. Right. So our next heading is the duty not to make misrepresentations or use harmful marketing techniques. All right. So no estate agent shall willfully or negligently mislead or misrepresent in regard to any matter pertaining to the immovable property in respect of which he has a mandate. All right. So this one is linked to the one that I went through previously that said you must disclose all facts which are material, which could be material to the purchaser or leasing. It's linked to this provision, right? So you shall not willfully or negligently mislead or misrepresent in regard to any matter pertaining to the immovable property, all right, in respect of which you have a mandate. I think that is clear and straightforward, right? Then you also have a duty to not use any harmful or misleading marketing technique or method or undesirable practice as declared in terms of Section 63 of the Act to influence any person to confer upon you a mandate to render any service or to sell, purchase, let, or hire immovable property, having regard to the general experience which such person has concerning property transactions and the circumstances surrounding the transaction or proposed transaction. All right, so the takeaway there, you may not use harmful or misleading marketing techniques, all right, to influence any person to confer upon you a mandate. All right, please keep that very important provision in mind. All right. Okay, so then the Code of Conduct sets duties in respect of offers and contracts. It says that no estate agent shall amend any provision of a signed offer prior to the rejection thereof, or a written mandate, or any contract of sale or lease without the knowledge and express consent of the offerer or the parties to the contract, as the case may be. I think that's also very straightforward. Before the offer is presented for acceptance or rejection, you may not make any amendments to it. Similarly, with the written mandate or contract of sale or lease, you may not make amendments to it without the knowledge and express consent of the offerer or the parties to the contract, as the case may be. All right. An estate agent shall explain to every prospective party to any written offer or contract negotiated or procured by him in his capacity as an estate agent prior to signature thereof by such party the meaning and consequences of the material provisions of such offer or contract, or if he is unable to do so, refer such party to a person who can do so. Again, the example of an offer to purchase, you can refer the person to the legal practitioner, conveyancer, if there are clauses that you yourself maybe won't be able to explain to that prospective party. All right, so that provision, I think, also is very clear and straightforward. All right, let's look at the next heading. The next heading is duties relating to remuneration. All right, so what is important for you to note here is that no estate agent shall convey to his client or any other party to a completed or proposed transaction in which he acted or acts as an estate agent that he is precluded by law from charging less than a particular commission or fee, or that such commission or fee is prescribed by law, the authority, or any institute or association of estate agents or any other body. And believe it or not, we still receive queries by consumers wanting to know if PPRA prescribes the rate of commission that may be charged by property practitioners. And this is based on information that property practitioners do sometimes provide to such consumers, telling them that, you know, PPRA has said that we only allowed to charge 12% or not less than 12%. That is prohibited in terms of this provision in the Code of Conduct. Right? So please take note of that. Commission, as far as my knowledge goes, is not regulated. It's what is agreed on between the property practitioner and that particular client. If the client is not satisfied with the rate of commission, the client has the choice of then approaching somebody else, another property practitioner whose commission is more acceptable to that client. But a commission is not regulated, right? All right, and then as I said, I'll go through undesirable business practices a little bit more in a little bit more detail. And in terms of the Code of Conduct, Section 35 of the Code of Conduct, it defines what is meant by undesirable business practices. And so if I can just summarize what is on the slide, it says that any arrangement that involves a homeowners association or managing organization, right, in terms of which that homeowners association will receive money or any other reward in exchange for a benefit or advantage or other form of preferential treatment in respect of the marketing of properties in such property development. So if you as a property practitioner arrange with an HOA or any other body corporate, in terms of which you will hand over a certain amount of money or other form of reward, in exchange for you being given a benefit or advantage, which an example of which would be for you to be able to go and market properties within that estate or body corporate. That is prohibited, right? That is regarded as an undesirable business practice. You may not pay money over to a HOA or body corporate in exchange for you being able to go and market properties in that estate or body corporate. All right. Then also you may not enter into an arrangement with an HOA or body corporate in terms of which you as a property practitioner will be designated by that HOA or managing organization as the only property practitioner that may market properties in that estate or body corporate. That is prohibited in terms of the second bullet point. Please take note of that. And then any arrangement that effectively provides an advantage to any one property practitioner or group of property practitioners over and above any other property practitioners in providing services in relation to properties in such property development. And then effectively excludes or disadvantages any property practitioner or group of property practitioners from being able to provide services in relation to properties in such property development. All right, so you may not enter into any arrangement in terms of which you will effectively be given an advantage over other property practitioners or groups of property practitioners, or that effectively excludes or disadvantages any other property practitioners from marketing properties within that estate. All right, please take note of Section 35 of within the Code of Conduct that defines what is meant by undesirable business practices. It is a contentious issue at the moment. We are busy prosecuting property practitioners that are contravening this particular provision in the Code of Conduct. We know that there are states out there that charge certain amounts as a prerequisite for property practitioners to gain entry and to market properties. For you to pay over that money is prohibited in terms of this provision. All right. Right. I think colleagues, I think that is my final slide, and I think I would have come now to the end of my presentation. So just in closing, I'm just going to repeat what I said earlier. Please familiarize yourselves with the provisions of the Act. I trust that all of you have copies of the Act available. And in that Act specifically focus on those provisions which impose an obligation on you to comply with that particular provision of the Act. And earlier in the presentation, I did go through some of those provisions. I think what stands out for me was Section 67, which says that you may not accept a mandate without a fully completed and signed mandatory disclosure form. A very, very important provision of that Act. Again, Section 48, that prohibits you from practicing without a fertility fund certificate. Section 54, which sets out the requirements for you to comply with regards to the keeping of trust monies. It must be kept in a trust account that must be audited, and audit reports must be submitted to the PPRA so that we can make sure that your client's trust money is being safely kept and properly managed in those trust accounts. All right. Please also familiarize yourselves with the Code of Conduct. Make sure you have a copy available at your place of business, that all your employees are aware of the Code of Conduct, are aware of the important provisions in the Code of Conduct. As I said, there's over 100 provisions in the Code of Conduct. It's not always possible to familiarize yourself with all of them, right? But do your best to go through the majority of the provisions, the important ones. I've tried to highlight in this presentation. Make sure that you are aware of them and that you regularly keep up to date with it, and that whatever conduct you undertake, it's always done, keeping in mind what is provided for in the Code of Conduct. Your conduct must be in line with what is provided for in the Code of Conduct. Right. Make sure that all your employees are familiar with the Act and the Code of Conduct, as I've said. And if you are unsure of anything in the Act or Code, you may contact me directly. And I think Naledi will share my email address with all of you. I've got no problem with you emailing me. And when I do respond to your emails, you will see that my contact information is attached to the signature in my email. So please feel free to contact me if there's anything that you want clarity on, or anything that you wish to discuss. All right, so we are here to assist. We want property practitioners to be compliant. As I said, we want to reduce the amount of complaints that we receive. We want to ensure that consumers are protected. And I think that the PPRA and property practitioners should work together in that regard, right? It's not a one-way street that only the regulator must ensure compliance. I think it's up to property practitioners as well on their side to make sure that they too ensure compliance, right, with the Act, Code of Conduct, etc. All right. Thank you very much, colleagues. That concludes my presentation. Now, Lady, I'll hand over to you.
Thank you so much for the presentation. I am quickly going to move to our second speaker. Her slides is only 6 slides. It's not a long presentation. Mr. Caton, can I ask you to hang tight? Your questions, I see them on the Q&A. I see them on the chat space. I see the hands. We're going to deal with the questions once we're done with the second presentation. Offense, can I ask that you unmute yourself and take us through the presentation? Thank you.
Thank you so much, Naledi. Can you just let me know when you will be able to see my presentation? I'm trying to share it now.
Yes, we can see. I see thumbs up.
Thank you so much again. Good day, everyone. My name is Ufindese Ate, and I am the manager of the Free State Rental Housing Tribunal. I didn't, like Naledi say, I didn't prepare a very long presentation for you guys today. I'm just going to take you guys through the headlines. The following is what I will discuss in short. I'm going to discuss the dispute resolution process of the tribunal, what the role and the authority of the Rental Housing Tribunal is, what we require in terms of documentation for our complaints, and our mediation and arbitration flow. So in respect of the Rental Housing Tribunal, we are a quasi-judicial body. The act that creates the Rental Housing Tribunal is the Rental Housing Act of 1999. Section 7 of that act requires that establishment of the tribunal be made by the MEC of Human Settlements in each province. And Section 9 of that act also details the composition details of the tribunal. So the MEC may appoint a chairperson and suitable members of a tribunal for a period of 3 years. The tribunal is an independent and impartial body. And I must also indicate that each province in the country has its own tribunal. So the jurisdiction of the tribunal is geographic in nature. So if the complaint arises from a property that is, for instance, in Gauteng, then a property practitioner or a consumer would then approach the Gauteng Tribunal. Some of the services offered by the tribunal. So the tribunal offers a free service to all the parties that approach it. The focus of the tribunal is on fairness and on harmonizing the relationship between the lessee and the lessor. And the jurisdiction includes all residential dwellings that are within the particular province that is being referred to. We don't cover commercial properties or commercial leases. We only deal with residential leases. However, the dwelling, as defined by our Rental Housing Act, is very wide. So it can include properties that are freestanding, properties that are in body corporate properties. It can also include informal rental properties in our former location or township areas, and so forth and so on. So the tribunal deals with what we call an unfair practice. So any tenant or landlord or any group of tenants or landlords or their representative may lodge a dispute with the tribunal on our prescribed complaint forms with regard to any unfair practice that arises. Some unfair practices can include...
Sorry, offense. I'm sorry to do this to you. I beg your pardon. There's a lot of comments on the chat. They cannot see your screen. Can I ask that you unshare and share again? Maybe it could be that we need to refresh.
All right, let me do that.
Sorry, colleagues. She will share again. Colleagues, can you see it now? Can I see thumbs up? Okay, they can see it now. Sorry about that. Please continue.
Okay, thank you so much. Okay, I will then resume from the slide that I was presenting from, which was slide number 5. And I was explaining some of the practices that constitute what we call an unfair practice. So this would include practices related to the changing of locks, security deposit, maintenance of the property. In respect of, for instance, on the side of property practitioners, it would include the non-payment of rental, the non-payment of municipal services, damages to the property that are that the damages made by the tenant in the property, and so forth. So those are the types of unfair practices that the Rental Housing Tribunal deals with. So when a party is approaching the tribunal in order to lodge a dispute, we require the following. We require a South African ID, a copy of the lease agreement, the physical addresses of both parties, and contact information of both parties, as well as any evidence that is related to the dispute itself. And with particular reference to property practitioners, we would also require, if a property practitioner is representing the landlord or the owner of the property, that they then have a mandate from the landlord. The mandate is specific to the tribunal that states that the landlord is aware that there is a dispute that is being lodged at the tribunal on their behalf, and that they will be represented by the property practitioner in all proceedings of the tribunal. And then finally, in respect of our complaints process, so once a complaint has been lodged with the tribunal, we will acknowledge the complaint, and then we will inform the respondent or whoever the other party in the matter is. We inform them of the complaint that has been lodged. And once they are informed, we will then require that they issue a response back to the tribunal regarding the specific complaint. Then we will do preliminary investigation. So, for instance, if the complaint is regarding a non-payment of rental, and a property practitioner has lodged a complaint against a tenant that they have not paid rent, the tenant will then be given a right of response, and the right of response must be issued to our offices. If the tenant, for instance, will come with a defense to say that the payment was made, we will require that all documentations then be given to us. For instance, that they must submit then to our office a proof of payment. And then once the investigations are complete, then we have a process. We have two processes. We have mediation processes and arbitration processes. So we, in most likelihood, all our cases will start with a mediation, where the parties will be called in with one of our tribunal members who will attempt to mediate or facilitate a mediation between the parties. If an agreement is reached, such an agreement will be reduced to writing. Both parties will then sign, and that will mean the closure of the file. However, if mediation fails or a mediation for some reason cannot be conducted, because we do indicate to all parties that a mediation process is voluntary. So if a mediation fails or cannot be conducted, then the matter is referred to the tribunal for a hearing or for arbitration proceedings. So in the arbitration hearing, there will be 3 members of the tribunal who will sit, and they will hear the evidence of both parties. The tribunal will then be able to make a decision, and the decision of the tribunal is a final ruling or a final decision. And according to the Rental Housing Act, is also equivalent to a magistrate court order. So this decision by a tribunal is only reviewable to the High Court, and it is considered a court order of the magistrate court. So I think, Naledi, then I will leave off for questions, and I will just indicate where our tribunal, specifically in the Free State, can be found. These are our contact details, the email address that we use, and our main office is located in Bloemfontein.
Thank you for a brief, quick, yet informative presentation, Ofense. Much appreciated for that. I think let's go to the question. I will start at the chat, go to the Q&A space, then I will unmute everyone to ask the question. Shak, can you please post a contact detail of Housing Tribunal? Ofense, she just did that. I'm going to share the slides, and you will be able to see all of their contact details on the slides. Let's start with a question on the chat. Anne-Marie says, you mentioned a South African ID is needed for the complaint to be lodged. Will passport suffice in the case of a foreign national when lodging a complaint? Mr. Caton.
Naledi, I think that's for the rental
That
housing
one is
tribunal.
Yes, I think that one is for me, Naledi.
Oh, yes. Beg your pardon.
Yes.
Please come through.
Yes, a passport will suffice. So we just need a valid identity document of whichever party is lodging the dispute.
Okay, thank you so much for that. And colleagues, can I say that Mr. Caton today is joined by Ms. Delinka Mbule to assist with the question related to lodging complaints and also the code of conduct. So you will hear her as and when we answering the questions. She will come through. She is the manager in the investigation, mediation, and adjudication. So she deals directly with your complaints that you lodge on the portal. I have another one coming from Anton. Can we please have clarity on the requirement that even rentals must have a disclosure document attached? The wording of the disclosure document points very much to sales and not rentals. No tenant is going to pay for a structural engineer to inspect the property, but we have to advise them that is recommended. So he posed the question, Mr. Caton, and also gave a comment in the same breath. So maybe if I can tell you the question again, can we please have clarity on the requirement that even rentals must have a disclosure document attached?
Now, lady, I'm not too sure if it's only me that is being affected, but you broke up while you were asking that question, and I'm not too sure if I got the gist of the question, but I will just say, mention what I heard. And my understanding is the question is asking whether, when it comes to lease of properties, whether a mandatory disclosure form is also required, right? Is that the question?
Yes, lease
Uh,
or during, yes, must they
yeah.
attach the
Yes.
disclosure?
So the short answer is yes. It does apply to leases as well, renting of property as well, because the provision provides that a property practitioner must not accept a mandate unless the seller or leasehold of the property has provided him with a fully completed and signed mandatory disclosure form in the prescribed form. All right. Malini, I may just mention here, right, that the form that is currently prescribed, that is contained in the regulations, we understand that this form does not meet everybody's requirements out there in the field, right? And so there is a communication that we sent out recently, um, notifying all property practitioners that if the form that we have prescribed in the regulations is not suitable for your needs as a practitioner out there. If it's not suitable for you as somebody that is doing rental properties, it's as an example, you may design your own form, right, that meets your own requirements. But before you do so, there's a process that you need to follow. You need to um, submit an application, an exemption application to be exempted from using the prescribed form, and then provide us with a copy of your proposed form. We will then have a look at it, and then if we believe that it's appropriate and suitable, we will then grant you that exemption and allow you to use your own form, right? I'm hoping that that covered the question. I didn't hear it properly, but please feel free, if I didn't cover everything that you asked in your question, please feel free just to send me an email if I didn't cover anything, and I'll certainly respond to you. Thank you.
Thank you for that. Offense, Saki says, can a tribunal adjudicate on a claim for loss of future rental due to a tenant terminating a 12-month rental agreement after 3 months?
In short, yes, they can, Naledi.
Okay, thank you for that. Does a WhatsApp message qualify as confirmation on a mandate as to say you can sell the house? Mr. Keaton, do you want to comment on that? It's from Adam.
Now, Lady, I'm
Daily
going to change my network. I mean, I'm getting.
Okay, it's fine.
I'm not
Daily,
sure
did you
why
get
I
the
am.
question?
Yeah, it's breaking up for me now, so I'm going to change my network, right? So
No problem.
just bear with me. Let me just change my. So I'm going to move out of the presentation, but I'll come back in on a different network.
Okay, let me give you a minute.
Okay, Naledi, I can assist Mr. Caton while he tries to rejoin. So in terms of the communication that of a WhatsApp, it can suffice. But however, it's important that you get it, a written mandate to be able to sell that property so that it's signed, because obviously WhatsApp cannot be signed. but to some extent it can suffice. But it's important that once you get that WhatsApp, you then at least send an email to confirm the conversation, and then you can also attach the WhatsApp. I hope that answer helps. Thank you, Naledi.
Thank you for that, Daily. Let me go to the hands. I'll come back to Q&A, Jack. Please, okay, let me give everyone access. While I'm giving everyone access, let me go to another question, Daily. How do we proceed with estates that are making agents pay to what they call registration fees from MPO? Daily?
Okay, so we have been on a drive to ensure that we deal with such conduct. We are then asking the relevant property practitioner who is faced with that problem to lodge a complaint with us. We are currently instituting disciplinary action against such, HOAs, because it is part of the undesirable practices that have been prohibited by the legislation. So if you do come across such a situation, we advise you to lodge a complaint, and then we'll deal with it as part of the undesirable practices. Thank you.
Okay, Amanda, where can we get this communication, please? You mean the slides? We will share with you the slides when we are done here. And Charlene says, what is being done by the PPRA on the issue in developments estates on accreditation and payment of so far? So I think it's the same question you just addressed now, Daily. It would seem to be a duplicate on that because
Yes.
it's access on HOAs. Jacques, please unmute yourself and ask a question. Okay, he's struggling. Let's go. Tembinkosi, if you can hear me, unmute yourself. Please ask your question. Tembinkosi? Okay, maybe he cannot hear me or maybe he stepped out. Marie, please unmute and ask your question. I gave you access, colleagues. Everyone has access now to microphones. You just unmute when you are recognized and ask your question. Marie, please ask your question. Not winning as well. Colleagues, can you hear me? Or maybe they can't hear me. If I'm going through one by one, I'm skipping everyone. Nicolene, please unmute and ask your question. Okay, let's move from Nicolene, not winning. Nils, unmute and ask your question.
Question for Offense. If a landlord refuses to release a copy of the lease agreement and there is a complaint, will the tribunal still accept that complaint?
Thank you so much for the question. Yes, the tribunal will still release that, or will still allow the complaint to be lodged, and would also then be responsible for requesting that lease agreement to be provided to the tribunal by the landlord directly.
Super, thank you.
Okay, let's go to Muzamil. Please ask your question.
Okay, my question is actually directed to Clarence. I'd like to know firstly is how long does it take for complaints to be handled? Because there is a number of complaints that has been logged over 9 months with different property practitioners that are operating in the Tungati area. And we're having a major issue where even PPRA was invited to actually attend a meeting, public meeting this last Saturday with CSOS, and PPRA failed to attend. And there is a number of issues where property practitioners are actually doing their own things, violating consumer regulation acts. They are intimidating. They're not following CSOS rules and regulations. There is actually cases of actually fraud, money laundering, misappropriation of funds. You got.
Okay, thank you for. Yes, you are breaking. You are breaking. Are you done with your question?
Yeah. So is the property practitioner that is a major issue. There is two. I did actually email Tato on this year, and Nakwanda from CSOS is actually meeting with y'all today to actually advise y'all on this here, because we as consumers our rights are being violated blatantly. And as I listened to Clearance advising that consumers' rights and everything, here our rights are being blatantly disregarded, where we actually follow the rules and regulations, the laws of, let's say, CSOS to remove the managing agents. But unfortunately, the managing agent, if I can, I'll actually mention the managing agent. And the managing agent gives a damn. He actually lies at adjudication processes, lies on emails, and we as consumers are actually suffering. What can be done? Because we laid complaints over 9 months about this year.
Okay, thank you for that. It also sounds that it could be a mandate of CSOs because our jurisdiction is limited to the legislation. Daily, do you want to address how long does it take for complaints to be resolved with the PPRA and issues of rates? I'm not sure if you have jurisdictions on that. Daily, just jump in.
Okay, thank you for that question. I think the client that is on the call, I am familiar with his case. And the process takes about 6 months to finalize in terms of a normal complaint. However, I should say that we do have complaints that are very complicated. So, for example, the one that he's speaking about, it involves 2 regulatory bodies, which is CSOs as well as the PPRA. And there are also complex issues that are involved because it involves trustees who don't see eye to eye. Some trustees are with the managing agent and the other trustees are against the managing agent. And in that instance, we have a number of issues that are disputed. So it does take a long time because there's also back and forth of communication between the parties. So it should take 6 months if it's not a complicated issue. But if it's a complicated issue, it will take us more than 6 months because there's then issues of exchange of documents between the parties. There's information that is contested. And I'm aware of this particular matter that he's speaking about. And CSOS has tried to deal with the side of the managing agent. We will only be able to deal with the conduct of the managing agent when it comes to the failure of the managing agent to apply the rules of the body corporate. Then we'll not be able to deal, and CSOS is the right forum to deal with that. Thank you.
The problem is we got complaints that is logged over 9 months. We have not received no communication, no nothing. We don't even have a case number. We have emailed a number of times to even get case numbers. So that because you see, we got a criminal charge against the managing agent for actually misappropriation of funds, fraud also, because these managing agents has actually lied at adjudication, CSOS adjudication processes. They actually lied on document affidavits that to the PPRA. They have lied under affidavits. Now the problem becomes is that we have logged cases against these property practitioners 9 months ago. We have sent screenshots that we have logged it. We got an email communication from PPRA stating that we can't find the case, but yet it's logged online. And that doesn't make sense to us because we as consumers are laying these complaints because these managing agents are actually, y'all are stating that they need to follow the bylaws, follow the rules, follow the regulations. But these managing agents are showing that they do not give a damn about the Property Practitioners Regulatory Authority Acts. They're not giving a damn about the laws. They're not giving a damn about anything. Only thing that they worried about is their pockets getting fat at the end of the day, while consumers are actually suffering. And you can't. And if you came to on last Saturday to Tungat, you would have seen 80-year-old people. You know what? It came up that if you speak to CSOS acting CEO, ask them for the the recording of the adjudication where it stated that an managing agent actually
So you are
stole
breaking,
our
but you
first.
know what? I did hear what you were saying, and I also heard the reply from Daly, and she did confirm that she received your complaints and she did communicate with you. But on your side, you had said
No,
it's been 9 months, no reply. But I remember even meetings, Mr. Caton met with you virtually several times. I think let's continue with that process. Let them give you a meeting and you continue with a complaint, let them assist you, because I do understand the frustrations that where PPRA doesn't have jurisdiction and they close your matter, you might feel like PPRA is not helping, but they have to
no,
do what they're mandated by the
it's,
legislation. So,
you see,
sir,
but complaints, Naledi, we have emailed through, we got this thing, and we do not have any responses where it's not even stated that the case has been closed. It's about mismanagement, about violation, where they are actually practicing without FFCs, the admin staff, things like that. There is serious offenses, but we are not getting assistance.
yeah, that's what I'm saying. You know, sometimes we have to be honest when we are in webinars because they've been communicating with you on some of the complaints where you feel you were not replied to. Can I ask that I send
No
you an
comment.
email address for Mr. Caton? And I know you have that email because you've communicated before. Let us look at those complaints, sir. Let us look at those complaints where you are saying they are not replying you. But I can assure you, because the process takes 6 months. Remember, if you are lodging 9 different matters, they will deal with them in, separately, because they can't deal with them with the same timelines. If you submit one in June, one in January, and one yesterday, one today, the timelines will be different. But Daly, can I ask that you just check and you contact him so we can move to another hand? Let's give others before we close, because there's a lot of questions. We have 21 hands, and I can hear your frustration and we see it. But I do know, because I know Daly, she has done a lot of complaints, and there's no way that she wouldn't want to assist you and not reply to you. So we have to check what could have been the issue on some of the complaints where you're feeling PPRA is not replying. But we will look into that. You can even resend me, because I know you have my email address. We've spoken before on email. Resend me those complaints and they will check the status of that matter, how far it is, because they have their own processes in the adjudication process. They have to look at both sides when they receive a complaint from the property practitioner or the managing agents and the complainant. They cannot receive a complaint and just decide that, oh, the managing agent is, they're wrong. They must follow those timelines and the processes. But we will assist you on that. Let's go to Corinne. Please unmute and ask your question. Okay, Corinne, I'll come back to you. Lee, please ask your question. Colleagues, are you still there?
Yeah, good morning, everyone.
Yes.
I have a question on the part when you lodge the complaint where it says it needs a South African ID passport. Okay, I am working in the organization as the one of property consultants. I have there is a department manager, there is the regional manager, then it goes to executive and the CEO. So here, the ID that you put, it's for who? Because I am just an employee who is managing the property.
A complaint with PPRA or rental tribunal?
With the tribunal.
With the tribunal offense?
So we request that the ID be that of the owner of the property. So if you're representing the owner of the property on a mandate, then you will give us the ID of the owner of the property, as well as the mandate signed by the owner that you will be representing them regarding the dispute that will be lodged with the tribunal.
Okay, thank you. I get that. And the second question, it's on arbitration, where it says it must have 3 members on the panel. So if it happens that it gets onto the stage and I see that there is a 3 members, so what do I do? Must I let it carry on, or must I question, or what is it that I do? Because I mean, as we all know that some of the things are not followed as written here, as in black and white.
You can definitely query that during the proceedings and let the members know that seeing as they are not, there's no correlation of members, you would request that they postpone the matter for when the matter co-rates, because it must be 3 members of the tribunal sitting for a hearing.
Okay, thank you.
Thank you so much. Let's go to Mark. Please unmute.
Good morning, all. My question is about the mandatory disclosure form. If a lease agreement or a sale agreement is concluded without the form, does that make the sale agreement or the lease agreement null and void, or what are the consequences of not having that mandatory disclosure form when that sale or agreement is signed?
That's an interesting question. Deli, come through.
Yeah, so it doesn't invalidate the sale agreement or the lease agreement. All it does, remember, a mandatory disclosure form is meant to disclose the defects that are in the property. So if there is a non-attachment or non-disclosure, it means that the property is either sold as it is without a non-disclosure form, without a non-disclosure of the defects, as well as it means the lease agreement has been entered into validly without the defects being disclosed. So it doesn't invalidate the contract. It simply means there were no defects that have been disclosed in respect of the sale or in respect of the lease. So the contract remains valid. Thank you for the question.
Thank you for that. Let's go to another hand. Matapelo, please unmute your hand.
Morning. My question is directed to Delhi and Offense. I'm going back to the HOA, whereby we as agents are supposed to be paying a certain amount for us to be able to sell or rent out properties in an estate. I've got a situation whereby a landlord was fined a certain amount because the previous agent was not registered. How do we deal with that? Are we supposed to report it to the housing tribunal, or what needs to be done? Thank you.
Daily first, then Offense will come.
Yeah, so we are not going to be able to assist the what do you call the landlord or the owner, but we will be able to assist the property practitioner who is being charged accreditation fees. And I did say in my previous response to a question similar to this, to say where you have been charged or are being requested to pay accreditation fee, please do lodge a complaint so that you can give us the full details of the that particular HOA and what they are requiring you to pay. And then we will deal with that complaint by then approaching the HOA. We have at some point in time had a meeting with the Association of HOAs regarding this particular conduct. And we have received, various letters from some HOAs where they have desisted from such conduct, and we are aware that some are continuing. So it means then we need to continue to put pressure on those that are still continuing with this conduct by obviously disciplining them and sending them relevant letters. So please lodge a complaint and then we'll deal with it. Thanks.
Offense.
Naledi, thank you for the question. I do believe that the Rental Housing Tribunal wouldn't have jurisdiction in such a matter because our matters only ever deal with the rental relationship between the lessee and the lessor. So, however, I do think that the landlord in this case would be able to also lodge a dispute with the CSOS against whichever housing association that they are a part of.
Thank you for that. I have a question in Q&A. Hendrik says, Does the tribunal hear matters close to the town where the tenant stays, or do they have to travel all the way to the provincial office?
Thank you for that question, Naledi. The tribunal does hear matters in the town where the dispute is lodged or the property is lodged, unless we are unable to travel. But in cases where the tribunal cannot travel to the parties, then we also use virtual platforms such as your Microsoft Teams in order for the parties to be heard.
Okay, Offense, while you're there, I have another one from Catherine. What type of qualifications should a mediator have at the tribunal?
So we require that our mediators have any type of mediation certificate or certification, whether it be through specific mediation organizations or institutions of higher learning.
Offense, Susan says, we stay in Port Alfred. Are the offices in East London?
Yes, Susan, there are offices in East London. And I also did indicate in the chats that I would share with Naledi the contact list of all the tribunals so that she can just disseminate it to all the attendees. So they have the contact details for all the provinces.
Yes, I will share those when I'm sending the slides. Peter says, Offense, before we move to Delhi, do rental tribunal have the right to evict tenants?
Unfortunately, no. The tribunal does not have jurisdiction to grant an eviction order. So an eviction order, parties must still approach either the magistrate court or the high court.
Okay, Maureen, I will share those details. I see your Q&A. The questions that I'm not reading out, it could be duplicates or either they were answered by someone else asking the same question. Gloria, I will put the email addresses that you are requesting. Let's go back to the hands. Ashla, please unmute.
Good morning. I'd like to ask the PPRA, when they drew up the act, our new act, they clearly covered that the mandatory disclosure needed to be provided on a sale agreement and on a lease agreement. Why did the PPRA, when they drew up the act, not provide a sale mandatory disclosure and a rental mandatory disclosure? Now, in the negligence of them not doing that, now it's the onus is on the property practitioner to do and be exempt from using the sales one because they're a rental agent, and it would have been as simple as the PPRA just putting out another mandatory disclosure which says landlord and relates to rentals. The process of getting exempt, I've been applying for something for exemption for months. And because the exemption process takes so long, what are the property practitioners supposed to do handling rentals now if they don't have their own exemption documents? It's just the onus has been put on the property practitioner when actually the PPRA could make this very simple and just make a rentals mandatory disclosure available to all rental agents.
Delhi, why didn't they do that? Do you know?
I'm not able to give reasons why, but I can say that it was an oversight in terms of the legislator when this legislation was being drafted, and we acknowledge that there was, this mistake with this disclosure form for lease agreement was not included. However, because the Act provides us with a powerful tool, Section 4 of exemptions, we are utilizing it. Unfortunately for us, it's not possible for us to just issue out or put out another disclosure form for rentals or leases. The simple reason is because this is a legislation, and a legislation requires certain processes to follow in order for you to amend it. We are currently in the process of amending some of the regulations, including the mandatory disclosure form. So in the meantime, we have put in the exemption process to assist with the disclosure form in respect of leases. So I do accept that there was an error in terms of the legislator in putting out or ensuring that we've got a mandatory disclosure for a lease agreement, but in place we've got the exemption, and we can't just issue out another one unless we follow the procedure, because this is a legislation. And then if you are struggling with I hear you say you are struggling with your exemption form, please can you send me an email, and then I'll be able to assist you with that exemption, with the exemption of your mandatory for a lease. Naledi, you can put out my email address. Thanks.
Yes, it's
Deli,
already there. It's already on the chat. Thank you so much, Deli. Natasha is asking, does the tenant need to sign the disclosure if there's no defect?
Okay, so a disclosure form is signed by the owner of the property, which is the landlord. And once the landlord has signed the disclosure form, what the landlord is trying to say is disclosing certain defects that are in the property. If there are no defects on the property, then there's the landlord will just also confirm that there are no defects. The tenant will also sign that there are no defects. There's nothing wrong with the tenant signing, confirming that there are no defects on the property. Thank you.
Okay, thank you. Amanda, please unmute. Let's hear your question. Amanda? Okay, I'll come back to you, Rachel.
Good morning. Thank you for taking my question. It's for the rental tribunal. I have a situation where the tenant reported termites on the property. The landlord requested 2 quotes. I gave it to them. The one was approved and the treatment was done. Now the landlord does not want to pay the invoice because they say it is for the tenant's account. I do disagree with that because that's a structural pest and not like cockroaches. Am I wrong? Am I right?
Thank you so much for that question, Rachel. I agree with you that it is structural in nature and is for the account of the landlord. I'm not sure why the landlord thinks it's for the account of the tenant, but I actually agree with you on this.
Thank you. Let's go to Melanie. Melanie?
Hello? Hello, can you hear me?
Yes.
Okay, this is for the PPRA. The question is, do rentals fall under the managing agent side of the sector or the estate agency side in terms of the PPRA resignation?
You're breaking. You're saying there's a rental on which side?
Okay, do rentals fall under the managing agent side of the sector or the estate agency side in terms of registrations of the PPRA?
Okay, your question is not clear. You're asking if PPRA can register managing agents.
Hello, can you hear me?
Can I ask that you type your question and I'll read it out? Yes, offense.
Okay, let me say that once again. Does rentals fall under managing agent side of the sector or the estate agency side in terms of registrations of the PPRA?
Does rental fall under managing agent side or property practitioners? Daily, would you want to take that? Because I know some property practitioners do rentals and managing, they just manage. It would depend to what extent. Daily, please come through for that.
So in terms of the rental space, it's the estate agent. So they will fall under the estate agency industry. Managing agents are responsible for managing, your body corporates and those type of properties. But if you are just doing your rental space, you would have to register as an estate agent.
Yes, true. Let's go to Anton.
Hi. In practice, we are obliged to do the rental inspection within 3 days of termination. In 90% of cases, the tenant is only moving out in the evening because they can only move into the new place the next morning. So in 90% of cases, I would prefer to do the inspection on the morning that they are moving out, because by then they've moved their furniture out and I can see what damages have been caused, etc. The Act is very specific. So what will the PPRA or the rental tribunal censure me if I do the inspection the day after the lease terminates, which is out of the law?
Daily, is it advisable?
I'm assuming that it's the Rental Housing Act that requires that inspection. So in terms of the PPRA, usually the lease agreement will provide for, inspections and when the inspection should be done. If the law insists that you are supposed to do it 3 days before, then I would advise that you do it 3 days before as required by the law. And you can also, in order to ensure that you get a full picture of the damages, also do it a day after they vacate, as per, what you have said that you would prefer to do it that way. But remember, there must be compliance with the law, and the addition that you would want to do is not also prohibited by the law. So if I were you, I would do both. I know that there might be costs to it, but, an obligation by the law must therefore be complied with, unfortunately.
Thank you.
Offense, do you want to touch? You have a follow-up? I wanted Offense to also maybe add before you follow up with your another question. Offense?
Yes, thank you so much, Naledi. Just to clarify that the Act, it is in the Rental Housing Act, it's Section 5, subsection 3, where it determines that the outgoing inspection must be done. But it's not 3 days prior. It says within the 3 days prior to the expiration of the lease agreement. So minimum at least the 3 days before, but you can do it 2 days before, a day before they move out, or the day before the lease expires. So doing it after expiration of a lease is not advisable in terms of what the Act determines.
Thank you for that clarity. Antonio, follow up?
Thank you. For my colleagues, what I've done in practice is I have my lease expiring at midday on the 1st of June, but the tenant must vacate by 8 a.m. on the 1st of June. In that way, I'm not falling foul of the requirement to do it within 3 days of expiration, but it is a bit of a get around of the law. My other question was about the mandate. If I see a client today and they are urgently wanting to sell their house and they ask me to take photographs, I'm not permitted to do so until they've signed the disclosure document. That doesn't make sense to me. Surely I can take the photographs today, get the disclosure document tomorrow on a verbal mandate.
Ndele, do you want to comment on verbal mandates? But I think you addressed it, but maybe to touch it again.
Okay, so I think if you look at Section 64, it says you can't accept the mandate unless you've been provided with a fully completed disclosure form. So your question was, can you take pictures of the property and then receive the mandatory disclosure form the following day? I suppose
Correct.
You can do it, but obviously it would mean it's sort of a problematic one. I don't know. You can take the pictures, but it means that the mandate is not in place, hey? Because the Act specifically says you must have the disclosure form. So I suppose maybe the following day when you get the disclosure form is when the mandate will be in place, because what the law is trying to do here is to say, as soon as you get the mandate and you advertise, you must be able to have the disclosure form with you before you can even then advertise the property. So I would suggest that let's comply with the law. Sometimes it doesn't make sense for us, in the field, but there are reasons why the law is as it is. So compliance is very important so that we don't find ourselves being disciplined for such issues. So for me, I would prefer that you have the mandatory disclosure form before you even take the pictures. It will save you a lot from being reported, because sometimes you can even be reported by the landlord, who will say there was no mandatory disclosure form when he accepted the mandate. So let's comply. Thanks.
Thank you.
Thank you, Deli. Lorraine, please unmute and ask your question.
Yes, thank you. Surely if we're doing an ingoing inspection with the tenant and landlord and tenant signs that, is that not a form of a disclosure? Hello?
Sorry, it broke a bit on my side. Offense, did you get that on your side? Deli, did you get that?
Yeah.
Or can I ask you to say it? Okay.
Yeah, she says, if I had her correct, she says that during the when the person vacates the property, they do an inspection of the property, and then she says surely that would.
I'm asking if at the ingoing inspection, if landlord and tenant sign the ingoing inspection, is that not a form of disclosure?
It's not a mandatory disclosure form, because the Act is specific as to, the format of the mandatory disclosure form. So it can't be a disclosure based on the fact that the Act is specific as to how and when the mandatory disclosure form must be done.
Okay, that's fine. Then second part, just this outgoing inspection 3 days before. A tenant can hide so many things with furniture. And so basically if I've got an agent who's doing 10 ingoings and outgoings, they've got to then go and do 3 days before and again. How is that? Who wrote the act? How's that logic? We do an ingoing inspection on an empty property, but then we must do an outgoing inspection with the tenant's stuff stored in the property. How does that make sense? Surely somebody has thought this through and there's going to be a change to the law?
Deli, do you want to comment on that?
I'll try, but I'll also ask Offensa to assist me with this one. I think, I did say sometimes the law doesn't make sense to us, when we are implementing, but there are reasons why the law is written as it is. In this case, and Offensa has stated it, it says within 3 days within 3 days of the contract expiring, you must conduct the lease agreement. So the inspection. So it means you would have to ask the tenants to push around the places that you want to inspect. I don't see another way of getting out of the requirement by the legislation, but you would then have to find ways to make sure that you do a thorough inspection by having some of the furniture, pushed around if it's possible. But Offensa can also assist me. I don't know what to say other than to say, the legislation is as it is and we must comply. And when the legislation is now open for comments, we do urge people that are affected by legislations, whether it's the Rental Housing Tribunal or even the PPRA, to come forth and make your comments so that legislation, when we're given an opportunity to change, we can change it such that it makes it easier for you to continue to operate. Thanks.
Offensa?
Thank you so much for that, Naledi. And I do understand the frustration of the previous speaker before Delhi. Our act, for instance, I know is a very old act, and we have been talking to the National Department about doing revisions to the act, because it's a 1999 act. We are now in 2025. I think the most recent amendment of the act is 2007. There's a 2014 Act also that is amending the original Act, which also has not come into operation. So we are in the process of also engaging with our national department about having an amendment or certain amendments of that act. And this is one of the reasons why, as Delhi said, it's so important for stakeholders to be engaged in such revisions of acts when the acts come up for public review or whatever the case may be.
Thank
Okay,
you.
thank you. Thank
Sorry,
you.
if I can just ask then, when it comes up for review, can the industry be sent an email to give us that opportunity? Because we're the ones on the ground, we're the ones doing the job, and we should be able to say, this is how it works practically. Thank you very much.
Yes, we will definitely do that. We've collaborated with Rental Tribunal. We'll make sure that all the practitioners that they get to comment will communicate that with them as well on their side. They will do the same. Ganyo says daily, can we electronically sign a disclosure form specifically with a sales agreement? Okay, we will come back to that one. Let's go to Jackie. Please unmute.
Good morning. Can you hear me?
Yes.
I've just got a question. If the owner stays overseas and he's not seen the property in a few years, how can they sign a disclosure agreement if they have not seen the property, or do they give proxy to the practitioners?
Thank you. Mr. Caton, do you want to take that one? Mr. Caton?
So the onus is on the owner to disclose any defects in the property. If the owner is going to give proxy to the property practitioner, that must be put in writing so that it's clear that proxy has been given to the property practitioner to disclose that defects and to sign that mandatory disclosure form on his behalf. I hope that's clear.
Okay, that's fine. Thank you.
Mr. Caton, I had another one on the chart. They were asking if you can sign electronically from Ganyo. The question says, can we electronically sign a disclosure form specifically with sales agreement?
Yeah, I'm not understanding the question because it's the owner or leaseor that is responsible for completing that mandatory disclosure form, not the property practitioner. There is a portion, on the mandatory disclosure form, it does allow for the property practitioner to sign it to confirm that it was submitted by the owner, but it's the owner, so I'm not sure what the person who asked the question means. But just to make it clear, that section 67 it's very clear. It's before you receive a mandate, you must get that mandatory disclosure form from the seller or leaseor, and it must be signed, fully completed. Thank you.
Okay, Delhi, do you want to take a bite on that?
Yes, I agree with Clarence as response, but also just to say that if the question is, once the disclosure form has been completed, can an electronic signature suffice? Yes, it can suffice. Remember, in South Africa, electronic signatures are valid and they're recognized by the Electronic Communications Transactions Act. So once the owner has signed, and you as a property practitioner or whoever is now required to put a signature, they can put an electronic signature. That will be accepted. It's valid. Thanks.
Thank you, Daly and Clarence, for that. Christine, please unmute.
Hi, thank you. So this is a rental question. The gentleman said that with all mandates, sole mandates that are extended, you had to get a new mandate signed. With a rental, you often have a tenant coming in for 12 to 24 months, and the mandate, our mandate reads, for example, the owner gives us a mandate for 12 to 24 months, and then we start marketing the property. The tenant sits for 12 or 24 months, but then gets an option period to stay another 12. So it's the same lease agreement, just being extended. You don't have to get a new mandate signed each time.
Offense? Okay,
sorry.
well, okay, you're back.
Sorry, Naledi, is that one not for Mr. Clarence or Delhi?
Yeah,
I'm not sure.
I think it's for me, Nalini, and I think maybe the person who asked the question misunderstood when I was doing my presentation. What I was speaking about was sole mandates. That if it's extended, that extension must be in writing and signed.
Okay, let's go
Yeah,
to
so exactly.
Oh,
but
sorry.
what I'm asking is if a rental agent has got a signed mandate and then gets a lease agreement signed following getting that mandate. So I get the mandate,
Yeah, but
sole mandate
that's
from
not
the
the
owner.
sole. That's not the sole mandate. That doesn't apply to that. You're not talking about a sole mandate. I was speaking about a sole mandate.
Yes, I'm talking about a sole rental mandate. If the owner only gives the mandate to rent his property to our company, it's a sole rental mandate. Or are you saying you are only referring to sales sole
Yes.
mandates?
Yes.
Only sales?
Yes.
Okay. Thank you.
Let's go to Elsabe, then Kerry. We will close the webinar shortly. Elsabe. Okay.
Good day.
Are
Can you
you-
hear me?
Yes.
Yes. Okay, I already in the chat box also put my question. It is a question to the rental tribunal. I often goes to the rental tribunal with cases where I represent the landlord, and in one or two cases the tenant as well. So in one of the cases, both of the landlord and the tenant agreed to pay the outstanding amount what the tenant was liable for. But the only dispute was about electronic remote fan control, which means the total amount due by the tenant, they just had to deduct 866 Rand from the total amount what the tenant owed. So the rental tribunal that sent completely the wrong figures with the ruling, where the tenant was supposed to pay, say, let me give you example, 8,148 Rand. They sent a ruling to say that the tenant just have to pay 1,048. So they thought it was a big joke because the ruling completely was not what was agreed there in the case, on the day of the court case. And then I intervened and emailed them and said, listen, this figures was completely wrong. Breakdown of what was used, what was owed, and with the total amount. And then they sent a second ruling again with the wrong figures. And then I intervened again. I went to the offices in Nelspruit, and I again made them aware, but this is not right. So they again sent the wrong information to the tenant. And at this stage, they think it's a big joke. They think these commissioners can't even do calculations. So it's very reflecting very bad on the commissioners or whoever did the calculations. But the tenant refused to pay this amount that he is agreed upon to pay unless the commissioners fix this and send them the correct ruling. So I just don't know what to do anymore to assist these clients. What can I do?
Thanks,
Thank you
Offense.
Thank you so much. Thank you for that question. I think that in this case, because I'm thinking most likely you have been dealing with what we call case managers or complaints managers. So I think that it might be time at this stage to try and escalate the matter to the manager of the tribunal, the secretariat manager of the tribunal, in order to get the issue addressed, and to request that the ruling be reviewed and be corrected by the members that were sitting in the case.
Thanks. Let's go to Kerry. Please unmute.
Morning, Naledi. This is for the PPRA. My first question is, and it just stems from a question that was asked earlier on about a signature on a mandatory disclosure form. Electronic signatures and digital signatures acceptable on those forms? Does that does that mean that now it's acceptable on a sales agreement or an after purchase? I thought it had to be a wet ink signature.
Okay, I think Dale, you did address it, but do you want to highlight on this one on disclosure, electronic signature?
Not just on the disclosure, sorry. Also, I'm asking now if it's acceptable
On the
on the
OTP.
disclosure. Is it acceptable on an OTP, a mandate, and all other agreements?
Okay. While she's still unmuting. Okay.
Yeah, Naledi, electronic signatures are accepted, but there are exemptions. I know that on a long-term lease agreement, they are not accepted. So specifically documents such as wills, contract of sale of immovable property, and long-term lease, these cannot be legally signed using electronic signatures.
100%.
So in terms of the other documents that we've discussed, these signatures are valid even for a mandate. If you look at regulation 34.3.1.3.1, a mandate can't be signed, electronically, but then there are exemptions that are provided by the Electronics Act, which is, as I've stated, a sale of immovable contract, long-term leases. So you would need to at least acquaint yourself with the exemptions under that act.
Okay, 100%. Thank you so much. Then my last question is an age-old question. Right at the beginning of the webinar, we spoke about compliancy and agents having to have their fidelity fund certificates. I've been in the industry now for 30 years. Please explain to me how we get our fidelity fund certificates. I'm battling like you cannot believe just to get my agent registered.
Can you please email me? I think I'll take up that query daily with the registrations unit. I'll ask Vukan and Deborah to quickly come in and assist on that one.
Your email address is just Naledi at the PPRA.
It's on the chat. I'll pin it so that it's pinned.
Thank you so much.
Kylie, please unmute.
Thanks.
Kylie.
Guys. Have a good day.
No problem, ma'am. Kylie. Okay, let's go to Sharika. Please unmute.
Good day to one and all. I've got a mandate to sell a property, but the owner is sitting with a problem. A previous agent put a tenant in there, and the tenant for the last 6 months is defaulting on the rental payment and squatting and don't want to move out. So on behalf of the owner, how does she handle this situation? Does she go to the rental tribunal, open a case? She started the eviction, but she don't know where to give the lawyer to start her eviction. But what do we do in this case? Because we also investigated that the tenant that was put there is illegal foreigner. She's not registered with the Home Affairs. She's illegally squatting there.
Okay, maybe before I allow offense, I want to say, Sharika, please, 2 July, we have a webinar with the CEO of Expelo. She's going to explain evictions. I think join that one and come back with that question again. Offense, I don't know if will you be able to address this one?
Yes, thank you so much, Naledi. I was just going to say that it would depend on what the owner wants to ask for. So if it's
She
just the
does.
eviction
She
that the
just
owner
wants the outstanding. She wants all her outstanding rental, and it putting her in financial dispute too. And she needs the tenant to move out, so give us the access to show our buyers the property.
So in respect of the outstanding rental, then the owner can approach the tribunal for an order for the outstanding rental. But in respect of
Okay.
moving out or the eviction of the tenant, then it has to go to the magistrate court.
Okay, perfect. Thank you so much.
Thank you, Alan.
Hi, Naledi. Thank you. My question is for Mr. Caton. This is the biggest concern we get from our network is if there is a complaint raised by a member of the public and the PPRA then requests further information from the property practitioner, when they respond to that request from the PPRA, they never hear back again. Some people have waited months and months and even inquired as to, the progress or anything like that, and there's just no response. Are we to assume that if you never hear back from the PPRA that the matter has been dealt with, or what is the situation? For people that take the law seriously, it is rather, it's rather stressful to have a complaint raised against them, and to not get a response to say where they're at is problematic.
You know what? Thank you for that, Mr. Caton.
Yeah. So let me just make it clear that we won't just remain silent and not deal with the matter, and that the matter will then just die a natural death. We will inform you if you are a respondent in the matter that either the matter is being closed or that we're going to proceed with the matter, and we'll inform you how we're going to proceed. So you're saying that your complaints from your network, I'm not too sure if you were speaking on behalf of other property practitioners, but
I deal with a franchise group, so this is what comes up in conversation.
Okay. So when somebody in your network does have a complaint like that, you have my email address. Please send me an email with the reference number of that particular complaint, and I can follow up with the legal officer that is assigned to the matter. But we close all matters in writing. We don't leave matters open, unattended and open-ended. We close all matters in writing, and if we're not going to proceed against the respondent, we will communicate that in writing. And if we are going to proceed against the respondent, there will be communication in that regard sent to the respondent. So if there are cases that there's a period of time that have lapsed and there's been no communication from our side, please ask that particular respondent to contact me so that I can follow up and get somebody to then respond to them. Thank you.
Thank you very much. I will do.
And maybe, Alan, to add on that, sometimes you find that maybe the email address of that respondent has changed, and maybe even if they are closing, they're reaching out to them, the email bounces. So if they were to check, you find that maybe the matter is finalized. Another reason could be that when they receive those comments from yourself as a practitioner or a respondent, they have to send it back to the complainant to say, here's a response, give us your comments on this. So that is another timeline, another process for that. Deli, do you want to add, or can I move to Angelique?
Naledi, if I can just add, I hear you guys and I accept that 100%, but there are cases, and there's one particular case where it's been like 4 months and there's been absolutely no communication.
Since the practitioner replied to PPRA?
Correct, yes.
They have a reference number, we will check. Please email me that reference number. I'll send it to Mr. Caton, and let's find out what. And Ellen, can I say thank you for that? It's always good to see when practitioners want to resolve matters, because sometimes they can impact on your FFC going forward if you were to be blocked. So thank you for always just replying to get matters resolved. And a complaint, you find that it's even nothing, after you reply, then it's closed. So we appreciate it, but send the reference number and we will assist you. I will put you in touch with Mr. Caton. They will find the attorney working on your matter internally in the investigations unit. They will assist. Let me move to Angelique. Please unmute.
Hi, everyone. Thank you very much. I have a question for Clarence. In terms of the with the mandatory disclosure and even with our lease agreements, I understand where the previous lady had asked with the question with the mandates is, if you have a lease agreement that has been already renewed over the last 3 years, do you need a new, say, property authority to lease that property when you are signing your new renewal, or a new mandate to lease the property in order to sign that renewal? Because I think that is where a lot of confusion is also coming through in terms of that, where we've got tenants that are in properties that have been there for 2 to 3 years already, but they are now up for renewal. I'll ask, do you need a new property authority to lease or a new mandate in order to do so?
My answer would be no. When I refer to sole mandates, I was referring specifically to the sale of property. So my answer to your question would be no.
Okay, perfect. That's one for you. And then for offence, I would like to find out by you if a landlord had proceeded with an eviction and the tenant had left, and obviously an eviction goes to the courts. The eviction was proceeded with, the tenant left prior to the hearing date and was actually happy to leave the premises. They just were struggling to find a property to move to, hence the delay in them moving out. We still currently hold that tenant's deposit. We have been instructed by the landlord to not pay that money out, yet we have had no correspondence with that attorney, for instance, to say what the costs, etc., are involved. Is the tenant that is being evicted liable for the costs of the eviction, even though they had moved out? Or can the landlord withhold their full deposit, or can the attorney ask us to withhold their full deposit until however long? What would your suggestion be?
Thank you so much for that question, Angela. It's a very interesting one.
I know, I'm sorry.
I know that the Act gives very strict stipulations on the timeline that a deposit can be or should be paid out to the tenant for. And I also know that in respect of court cases, in cost of the attorney and given by the attorney of the one party can unilaterally decide that the other party must pay the cost. The cost of their account is always to their specific client, unless the court makes a specific court order that cost must be paid by the other party. So I don't know if that answers your question or not, but to me, I think that
Okay, no, thank you for that. Let's go to another hand, Sivuyile.
Hi, thank you, Naledi. My question is to do. There's a problem that we are experiencing with the tribunal in our province, in that there always seems to be an issue with regards to service of the summons to appear before the tribunal. And my argument has always been to the Secretariat that in terms of the lease agreement, the address that is confirmed there by the tenant is the domicilium. And as far as I am aware, that if the summons is served there, then it's incumbent upon the tenant then, who's the respondent in the matter, to then deal with it. So we are having issues where the Secretariat of the Tribunal is under the view that we are then supposed to incur further costs in terms of tracing agents to confirm that service of the summons has been served. And that is essentially my question. How do we deal with the issue of service? Because sometimes the tenants have vacated the property and now we're going after them for unpaid rentals and things like that, but we're unable to serve the summons. Thank you.
Thank you. Offensive.
I hope I got your entire question, Sigu. I was cut off at some point. But I do know that that remains a problem with all the tribunals, including ours as well. And the advice, because unfortunately the tribunal within the Secretariat itself, we do not have in our employ tracing agents. So we will request in such cases for the parties to employ, if they can, tracing agents for the parties to be able to be served properly. Unfortunately, that's the case with most, if not all, of the tribunals.
Okay, thank you for that. Let's go to the last hand before we close. Lee, you are the last hand.
Yes, thank you. I'm back. I just want, I'm seeking for an advice to anyone that can give. What do you do? Okay, the tenant was owing, the tenant has paid his or her account, it's now up to date, and you are starting the process of renewing their lease. You've prepared an offer of the renewal, we have sent it, and no reply. So you waited and waited, then you wrote a letter with a little bit of, threats, and still no reply. So what would be the next thing for me to do as the property consultant? I'm not too sure what's next, because I don't want to start handing them over and all those things. But what else? What would be the next thing that I can do? Because my last letter to them, I'm not going to read everything, but I said, please be aware that if we do not hear from you by a certain date, we will have no option but to send you a formal notice to vacate the premises, advertise the property for new tenants. And still there's nothing, it's just quiet.
Okay. Yeah, I got that. Earlier I mentioned that next week I'm having another webinar on evictions. There's a company, a private sector, that will come and present that. I think also see an email on the chat for Mr. Caton, but please join that webinar. I think it will assist. I have two hands. Let me just take the last two so that I don't disadvantage you, because I also need to release the speakers and also our guest speaker. They have other meetings. Jonita.
Hi, yes, I just have a question. If is a body corporate permitted to request a 5,000 Rand move in or exit deposit prior to allowing the tenant to move the furniture in and out the complex? The amount is refunded if there is no damage.
Is the question for you want to know the tribunal, with the tribunal?
Yes.
Offensive, did you get that, or your line is you're still struggling?
I think that would also be something that would fall under the purview of CISOs as well. But
you're breaking.
I'll try and type it.
Okay. No, thank you so much. Let's go to the last hand. Alex. Janita, Offensive will reply on the chat. Her line is terrible. Let's go to Alex. Do you have a follow-up, Janita?
Sorry, I couldn't hear what the response was.
She's saying she will send you the reply on the chat right now. Look at the chat. She's replying.
Okay, thanks so much.
Because of her network. Yes, her network is terrible. Alex, please unmute. Let's take your last question. Okay, Alex, can I ask that you put your question on the chat? Maybe you can't hear me. Colleagues, thank you so much for joining the webinar today. I am going to share the slides. I am going to share the recorder with everyone who attended because it will give me an attendance register, so I will be able to see all of the email addresses you will get. And if you are not registered for the webinar, you still have my email address. Send me an email anytime. I'll send you the slides. Some of the queries that are not related to the presentation, I've shared email addresses. Also, mine is there. You can email me because I saw somebody inquiring about payment allocation. Send me that query. I will forward it for you to the finance department so they can allocate payment for you. They will assist you. I'll ask Mashudu. He responds very quickly in finance. Colleagues, as we wrap up, I want to thank really the speakers today for their time and sharing the knowledge with us today. And I know we went over time with 20 minutes, but it was worth it because we needed that awareness. Thank you also to all our attendees. Your participation, it plays a big role, just advancing what we are trying to do as PPRA under Section 69 of bringing awareness to consumers and property practitioners and compliance in the property and rental sector. So today, let's take what we've learned, colleagues, today. Let's share it with people in our communities, your clients, and also your colleagues who couldn't join today, because informed consumers and ethical practitioners, this is what is going to make us to function properly in the property market. Thank you once again. And I am going to share the recorder within 48 hours on our YouTube PPRA TV. You can go back to that if you missed some parts of it, and I will email you the slides. If you have questions that you remember after the webinar, feel free to email us the questions. Mr. Caton's email is on the chat. You can email him anytime. I know they also consult daily. I know you also consult in your department. There's consultants, there's admitted attorneys in Delhi's department. They can consult for you on email, on face-to-face, and also virtually. Come see them. If you want to lodge a complaint, you can lodge that complaint on our PPRA portal under lodge a complaint. There's also a whistleblower. Let's say you want to whistleblow one of your colleagues who are doing illegal things. You can just send it anonymously on Vuvuzela. It's also on our website, and our adjudication department, we will deal with that. Also, I will share information coming from offense on national contact details, because I know most of you are in different provinces. So they will be able to assist with that. Thank you. Please stay informed and take care of yourself. Until next time, we will communicate. Thank you. Goodbye.